I'm now joined by a man that I get to sit in this room with him every week talking about the law side. And well, law side's hit mixed martial arts as I do my show last week. News comes out, Cain Velasquez, a former UFC heavyweight champion. He has been arrested, multiple charges, including attempted murder. And so this has been a huge topic amongst the mixed martial arts community. And of course, I'm joined by the Lawfather, Franchi. Of course, you can listen to his podcast here on Radio Influence. Of course, also on all the major podcasting platforms. But I want to get your legal take because the MMA community is, I think, reacting it from a human side, where they're sitting there saying, if that was my relative, I'm doing the same exact thing. And of course, I think everyone knows the story on this one goes back towards the end of February where the man in this case, Harry Gallart, allegedly sexually abused a close relative is the way it's being defined. If you go on social media, you hear other fighters, I think everyone knows the relationship there is to this. But I wanted to get your side of the equation. First off, so he gets arraigned last week. And I guess what was odd to me was he's arraigned, but bail is delayed 4 days. Why is that?
And that's not typical, right? Typically, one follows the other. And so arraignment, just to kind of touch on that, that's when you either plead guilty, which I don't know who ever does that, okay? Or you go not guilty, right? And and actually, honestly, at least here in Florida, a lot of times you get your bail first and then your arraignment's sometime after that, right? So it just kind of depends. But, typically, especially when you're talking about somebody who has, and I would imagine he probably travels a little bit internationally, right? Especially, he's definitely domestically traveling, but I would assume with the MMA and being the level that he is, he's doing some international travel. So sometimes there's these thoughts of, okay, we probably need to gather some more evidence just in terms of, is he a flight risk? Is he not a flight risk? What are his ties to the community, right? So those are the types of things that you're looking at when they're trying to determine bail, and that may not have been something that they had at their disposal immediately. Or it could actually just be that state is how they do it, right? So every state's a little bit different. Truth be told, every county is a little bit different. So even here in Florida, we see small differences in the way people do things. But generally speaking, they look at the complexity of the crime. Sometimes they look at the amount of evidence they have against the person. I think they have a decent amount from what I've seen so far in this one. Video tells a lot. And is the person a flight risk? And are they going to do this again, right? So is there other circumstances that you might not want to let the person out?
Yeah, the bail hearing was today, and Mark Aragos, who's representing Cain Velasquez, was attempting to get bail. Says, hey, well, he'll turn over his passports. That was not the case. The judge in the case says it's clear to this court, and it's clear and convincing evidence that there's substantial likelihood that release would result in great bodily injury, not to be named, not just to the named complaining witnesses in the case, but to the Santa Clara residents at large. This case involves allegation of extreme recklessness to human life, ramming a vehicle in the middle of the day, or our citizens out driving, going about their business, and shooting out of a car at other individuals, which is reckless by any standard. Anyone could have been injured. Anyone could have been killed. And when this court looks at Article 1, Section 12, it's the level of risk that is the most we must take into consideration. With that being said, the court is making the ruling that the risk is too great and that there will be no bail set at this time, which this is just... everyday man sits here and looks at this case, and I say, okay, I'm not trying to sit here and say Cain should be released.
Yeah.
But I'm also looking at the other aspect of this story where I go, just days before this incident, a man, and this is a quote from a news article I found. Velasquez was arrested on Monday after allegedly shooting a man while targeting another man accused of molesting a family member possibly 100 times. That man is out on bail. And I think we look at that and say, is that just something that's wrong with our judicial system, that someone be accused of something of molesting a child, he's out with an ankle monitor on, while the guy who basically decided, I think the judicial system has let me and my family down. And look, I'm not trying to say he should have done this.
Yeah.
But I'm just saying, I look at that and say, how is this guy not in jail?
Right. Yeah, so kind of a few things there. Let's start with the bail part for a second, because if you look at it, you are guaranteed, you're protected by the Constitution and the Bill of Rights to not have unreasonable bail, right? Mm-hmm. Different from you can have bail denied. So it's not a right that you actually are allowed to be bonded out, Okay, it's just you're guaranteed that the amount won't be unreasonable, but the amount can be zero, meaning that you're staying, right? So there's that aspect to it. What I'm having a really hard time wrapping my head around is, where did the justice system fail Cain Velasquez? The guy was out on bail. The guy hadn't even had trial yet, right? So this guy who's accused of this lewd and lascivious act, okay? And look, talking strictly from the legal side of things, right? Because there's a difference of, and I'm a little bit amazed, I guess, by the outpouring of support for Velasquez, because every MMA fighters, Twitter, general public, hey, we're going to stay here and protest to free Cain until he's out, right? But and the underpinning theme is, well, the justice system failed. Well, where did it fail? Because the guy isn't the victim in this, the one who is the alleged lewd and lascivious guy, right? He wasn't found innocent. The state didn't drop the charges. He still has a trial pending, and I think you said he was on an ankle monitor?
Yeah, I read that.
Maybe I'm missing something. Maybe from another perspective, where did the system fail him?
But I think we all look at it, and I guess this is like the human aspect of the story, where we're sitting there saying, if that was our family member, we're probably in the same mindset that Cain Velasquez was in.
I'll give you the same mindset, but then I guess sometimes you got to go, hey, you know what? Maybe I shouldn't do this, right? And look, it's one thing. Here's the real easy way to differentiate this, right? Cain Velasquez sees this guy at a bar, beats the crap out of him, right? Probably getting a pass, right? What state attorney is going to take that and run with it and take it to trial, right? Probably going to offer you a sweetheart deal. Yes, you get a conviction on your record. Yes, that prosecutor gets a conviction on his belt, right? But guess what? It probably dies a slow or a quick, quiet death that no one cares about.
Okay, so looking at it from a legal aspect, let's say he doesn't have any guns on him.
Yeah.
He's not shooting him at all. Let's just say he decides, you know what? I found this person. It's an 11-mile chase, and he's ramming with his car. And let's just say he's able to stop that car, pulls the guy out, beats the crap out of him.
Yeah.
How different are the charges? Could you still say attempted murder because maybe the DA argues his hands are a deadly weapon?
It's even simpler than that, right? So you could take it. It could be you or I, right? I am not an MMA fighter. I don't think I've never heard that you fight MMA. So we're gonna go with that neither one of us are. The car's a deadly weapon. By mere fact of him ramming the car, there's an attempted murder charge times 3 because you have 3 people in the car, right? So there you go. You have that. Now, truth be told, you potentially have more serious charges if he didn't have a gun and did a shooting, right? Because here's what happens. So, and you got to kind of change your mindset and what you think of with the law in some of this. Because if I tell you that it could be a burglary, right? You'd say, well, that he didn't steal anything. But a burglary, you just have to have the intent to commit a crime therein. That's the phrasing of it, right? So if you go into a car, right? So Cain Velasquez rams him, does everything else. Both cars stop. He goes, opens the door, reaches in. Okay, now he's breached that threshold. He's now inside that conveyance. The car is considered a conveyance. Okay, he's gone in with the intent that he's going to commit a battery, meaning that he's going to hit this guy. Right? There's your burglary. So instead of burglary / theft, which is what we would typically think of, you have burglary because you went in and you intended to commit a battery. So you pull him out and you hit him. There's your battery. Potentially worse in terms of charges because now if you kill a guy, now you got felony murder on top of it, which felony murder is kind of just a step below a first degree because you don't have to prove any premeditation, right? It's really in line with the first degree. So you could actually have a potential for the charges to be even more serious and that, take the gun out of it.
Yeah. And of course, that's what a lot of these charges, when you look at the 10 counts that are out there, in terms of now, let's just say you're Mark Garagos. Obviously, this is going to be a tough case for, is the thought process, I just got to try to get this pleaded out to limit jail time?
I mean, possibly. And maybe you try to figure out how to get the state to split the baby because I like my chances better in a trial against the person who was out on bail, the one that was accused of lewd and lascivious. I like my chances better. I still don't like them because I don't know how you separate the facts of you have two other people in the car, right? And so I think that changes the dynamics of the whole, is that you have these two people that are here. They didn't do anything wrong other than, they hang out with this guy. But maybe they don't know.
Yeah.
So you don't even know what they know to even know if they have any involvement. But even if they did have involvement, legally, I don't see where there's a right to this. And God, the defense has such an uphill battle. Yeah. I'm not even sure that I see an out, especially because there's video of this. There's video of Cain Velasquez tracking this guy, and you can see the damage on the car, and it's just, man, I don't know how you're going to create doubt in any of this.
From the prosecution side, and let's say this goes to trial.
Yeah.
Now you got to sit a jury. 12, I'm guessing it's 12 people in the state of California.
It depends, but in something serious like this, it most likely is.
So if you're Garagos, you just need one person to convince. How do you get a trial? Because I got to imagine if you're Garagos, you want 12 fathers on that jury.
Most likely. But I mean, some of what you get for jury is by chance, right? So it works like this. You have a bunch of people, and I haven't done one since COVID, right? So, and California, God knows, they're a lot different than we are here in Florida, right? We're the wild, wild west of COVID restrictions. But typically you have a box, and it's really structured like a box, and you have, either 12 seats, usually 13 seats, or 7 seats somewhere in the box, right? 12 or 6 jurors plus an alternate. And in a bigger case, something like this, there's probably going to be a couple of alternates. But they start at juror 1, and they seat them usually left to right as you're looking at them, right? So you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and you usually have, depending on the severity and like I said, like one like this, your jury pool is probably going to be about 100 people, I would guess, for something of this nature, okay? And it's compounded by the fact that he has a public name, right? So you need a bigger jury pool. But anyway, you go through, and if you have no objections on what, let's say we're using 6 people, right? 1 through 6, those are your 6 jurors. That's how it goes. And then so what the attorneys are doing back and forth are they're asking questions, and the state's going to kind of phrase their questions, and you're going to try to put as much out as you can. It's really tough because you're not really allowed to get into the facts of the case, right? But you're going to get enough out there to talk in hypotheticals to get the people to understand what your viewpoint is on the case, right? And really good lawyers can do a really good job. I've sat in on cases where I've watched this happen. I've watched the jurors eat up what the state's saying, right? And then my trial partner's gone in and he's on his side. And I've seen that mental switch of the jury going, oh, or the jury pool going, oh, didn't quite happen like that.
I'll give you, so the last time I was had jury duty.
Yeah.
I got called back. So this is obviously pre-COVID. Called back. So I'm probably like, I don't know, there's probably 30 of us in the room.
Yeah.
And so, we walk into the courtroom, DA's office on one side, defense on the other side, the defendant's sitting there. And I remember there was a lawyer, a part of the jury pool. And the judge like, oh, Mr. whatever his name was. Oh, I recognize you. And I'm like, oh, there's no way that guy's getting picked. Yep. But then I remember there was a point where it was clearly a case of a molester that the person did not come forward till years later because the way they kept asking the questions.
Yeah.
And I remember how many times the judge would say, we're just picking the jury. You're not presenting the case. But I feel like in this case, if it does get there, both sides are going to have to do that to try to find the person that they truly want on the jury.
Right. Yes, but keep in mind, you only get so many, right? So they're called preemptive challenges. You have, those are take a step back, sorry. You have challenges for cause, which is what you kind of just described where you're asking the questions. And then you have preemptive. Preemptive, you get 3, and I could pick 1, 2, 3, done, right? And they can't be discriminatory, right? But it's one of those things. Did you not pick the guy because he was a guy or, because of his race or whatever else? No. Okay. Next. Like, you're ever going to get to anybody to go, yeah, that is why, right?
I remember specifically, they went through all the questions. So it was like, I don't know, half hour, going around the whole audience asking various questions. We go out for a break, and I looked at the guy next to me. I go, I already know who the jury is. He goes, what do you mean? I go, they kept asking the same 6 people different questions. So clearly those are the jurors. Yeah. I go, so we're good.
Yeah. Yeah, you can start counting. I mean, I've been in that same kind of situation where I've got called back. I'm sitting in there going through, it's called voir dire when they're asking the questions. And they actually came to that same question when they go, does anybody know anybody? I'm like, yeah, that defense attorney and I have gone against each other, and I know that plaintiff's attorney very well. And it was like, yeah, you probably can't be impartial with that defense attorney. I'm thinking out loud, I go, yeah, of course I can. But we all know, it's tough. You're an adversary. It's tough to turn that switch, right? But, that's you're right in that you can start figuring it out. And the problem is not problem, but on the one side, you're trying to figure out who the other side likes and who they don't like. So you can start, because you only get so many questions and you only get so much time. So you got to start going, okay, do they like that person? Do I not like that person? Because I have 3 and 3 and they have 3 and 3, and I don't want to waste my 3 if it's going to be someone they're going to waste theirs on, right? So there's a lot of tactical aspect to it, right? And a lot of times it'll go, okay, the state will they'll go, okay, I want that person for cause. Then they'll remove that person. Then the defense will go, okay, I want that person for cause. So they'll use, or for the preemptive challenges, usually do first, right? Because then for cause, there's a lot of explanation that has to go on. So you go, I don't want juror number 1. Well, why not? Because that person said that they had been molested in the past, and they said that they couldn't be impartial and get past that. And clearly anybody who's been convicted of it or has been charged with it is guilty, right? Okay. That juror is going to go away. So, and they'll do things, you'll hear them try to clean things up. And so the state will ask if someone can be, if they're upset by something, and they'll go, yeah, no, I don't think I could do something like that. And then maybe the defense really likes that person. They'll go, well, do you think that you can follow the judge's orders and be impartial? They'll go, yes. And then a lot of times when you come back to that back and forth with the judge will have made notes. Well, that person said they could be impartial, so they stay.
Because of San Jose being such a huge mixed martial arts community, don't you think the DA may try to get the trial moved out of that area in terms of a jury pool?
I mean, I think it's a big enough area that I would imagine you should be able to get a jury pool without much of an issue, right? I mean, you look even at something as big as OJ. I don't think they changed venue in OJ's case. I think they kept it right there, and OJ Simpson, that is, and that was a big case with a big name, right? So yeah, I can't see something like that changing venue for it. You'll need a bigger jury pool, but I mean, just think of how many people there are that don't like sports, period, and that essentially becomes your jury, more or less. Because
of this is going to be such a hard case for them to get a not guilty verdict on.
Yeah.
Do you think that if you're Garagos, are you already going into plea negotiations at this point?
I think you always do anyway, because you got to know what you're working with, right? You have to know what your risk is. Trial is always a last resort, at least in my opinion. Trial is always a last resort because trial comes with risk. You don't know what's going to happen. You control your own destiny up until trial. Mm-hmm. So it's kind of nice knowing what that destiny looks like, right? Because if that destiny looks like 5 years instead of life, maybe that's something you consider. Now, I mean, that said, I don't want to spend 5 years in any jail or prison, but I also don't want to spend life in one either. So, I don't know. I would probably avoid doing something like this.
Like, as I look at count 2 through 10, which are all related to the gun, like, how can you prove innocence from a legal, like, is there any way from a defense aspect that he can tackle these counts, or do you just, or is the mindset as a defense attorney that you sit there and say, hey, we just got to try to lessen the attempted murder charge.
I mean, you got to try to lessen the attempted murder charge. And he's got so many counts because they're duplicated, right?
Because of the 3 people in the car.
Exactly. So you're shooting at a car. You just bought all 3 people, right? So you bought 3 counts, right on the outset, right? Carrying a loaded firearm with intent to commit a felony. I always love that one, and it's so duplicative of everything else, right? I mean, yeah, I committed a felony. Now you're going to charge me for having a gun for the felony charges all stem from this gun, and now you're going to hit me with an additional one, right? I never really liked that one. I never really understand how in our criminal justice system we get away with it because it seems so duplicative, and I know our system doesn't necessarily love things being duplicative, but shooting at the occupied vehicle, that's a problem, right? And here in Florida, actually, I've had a state attorney threaten to do this to me before, not to me, to my client at the time, that they would charge him with a burglary and aggravated assault because the bullet passed through the threshold.
Wow.
Yeah. I don't think it would fly, but they would try that. But one of the things that I saw, actually, and to get away from the legal side of things, partially legal side, but to kind of keep in mind, those of you carrying a firearm out there, it would be very helpful, right? Because they found two casings in his car. So we know he fired his gun at least twice. Now, here's the thing. They say how many rounds the magazines for the guns that he had were, right?
Correct, yeah.
And they may or may not know how many slugs were in the car itself. But just as a simple note, right? If you carry a gun, keep your magazine loaded to the top. And I'm not saying because you need all the rounds, right? But if you're ever in a situation where you have to use that gun, the question's going to be, well, how many rounds did you fire, right? And I'm taking this from the law enforcement training. So what we would do is they would have us, you always have to make sure that your magazines are filled to the top, partially because we need to make sure we had plenty of ammo, just in case, kind of crap hit the fan, but then also you had one in the chamber. So you always knew the amount that you had. So it was partially so that you would be well protected, but partially then so at the end, if there was a shooting, they would take the magazine and they would count the amount of bullets that were left. And then they could go, okay, you fired the gun this many times. So just kind of food for thought for those of you who carry, right, to keep that in mind, like fill it the same way every single time. And that way, if something happens, you can go, I put this many in every single time. This is what's left. I don't know how many I shot, because typically in those situations, you don't know.
And that's in the statement of facts. This is mentioned. It says Morgan Hill police located and recovered a .40 caliber semi-automatic handgun in the suspect's vehicle and turned over custody of the firearm to the San Jose Police Department. The firearm was loaded with 9 bullets and a 10-round magazine. Another magazine was located in the console, which contained 3 bullets in a 10-round magazine. 2 spent casings, .40 caliber casings, were found on the front passenger seat, which we'll leave on this.
Sure.
You have this line that you like to say. It's not what you know, it's what you can prove.
Exactly.
So from the defense side, do you have to sit there and make the prosecution prove that they can prove that those bullets were shot from his car at that time?
Yeah. So here's the great thing. Well, I don't know if there's any great thing for the defense on this one, but the great thing on the defense side is you don't have to prove anything. The state has to prove everything. So if the state doesn't prove it, it's done. It's over with. Right. So, yeah, we may know this, but if they can't get the evidence in, so it's just, and that's a good point. We've seen this video, right? It's out there. It exists. Yeah. If they can't ever get it in, it doesn't matter that we know what's on that video, but we can't prove what's on that video. So can we prove that his truck rammed his car? I mean, yeah, there's probably going to be other ways to do so.
Yeah.
That's generally a pretty easy one because you can match up pain and you can get kind of crazy with how you do that, but it's not what you know, it's what you can prove.
Yeah, that's a line I hear you say it every week. Of course, let everyone know they can find on social media, and of course, anything else you want to mention, man.
Sure. Just check me out at the Lawfather at all of our social media, YouTube, everything else, and check out the Lawfather podcast as well.